In this video, I'm going to introduce you to what is a socio-legal analysis of constitutional law and help you understand how that's different from what's called legal formalism. The big picture is to just very, as concretely as you can, or as down to earth or everyday experience as you can, is just to understand that there's a tension, that there's two things that are competing with each other. On the one hand, there are traditions that are passed down from generation to generation that are necessary to establish and maintain some social control, but to understand that these are social control over unequal social relations. So those with more power are controlling those with less power. This is in tension with newer ideas of freedom, liberty, and resistance to people who are experiencing unequal social relations, who want the traditions to be different to match their ideas of freedom. So these things are constantly in tension. So there's two ways to then think about a constitution. The first is the idea of having a constitution to organize society as a project, something that we're trying to perfect. This is at the beginning of the United States Constitution in order to form a more perfect union. This is kind of the idealistic idea of trying to organize human beings in such a way that there's less division and less inequality over time. This is an idea that started arguably in the 1700s and 1800s during the Age of the Enlightenment, but that's what led to the ideas that the so-called Founding Fathers were interested in trying to implement in real life, looking at previous systems of government and learning from what was going on at the time, and justifying their violent overthrow of the British government and their violations of British law. And this is justified in the Declaration of Independence. According to them, when the legal system and government system of one government is abusing and taking power away from you as a group, or if the unequal social relations last too long, then you have the right and your duty to overthrow that government, to replace it with something that's better for you. This idea, this view, seems to invite a lot of people into the political body, if not everyone. Everyone gets to participate in a discourse, a conversation around these ideas of rights, self-government, and what the state should and shouldn't do. And this is what we typically discuss as politics. It is a common framing of liberal constitutionalism found in popular culture, news media, education, and law schools. And the idea here is that the Constitution is the whole reason for having a government in the first place, and this is why we're all involved in it together. And again, that's a very popular way of looking at it, but it's not the only way of looking at a constitutional order. The other way to look at it in a much more practical way, or a way that lawyers and judges tend to think about it, is more as a constitutional system. So it's also the actual material departments and functions of the states. This includes written customs, practices, beliefs, civil society, the clubs, associations, and competitive mechanisms like anti-monopoly law, things like that, that we call private law, supports outside of the formal ordering of a constitution. So it's not just the so-called checks and balances that you learned as a project. It's also the probably millions of little laws that you don't think about, the municipal codes, the right to make a contract, the rights that you get when you form a marriage contract. There's all sorts of things that we could go on and on and on about that are also part of this system that we call a constitutional system. And so representations of the so-called people, the people is not a material thing. It is not a thing that we can point to and say these are the people. It's a product of the written customs, practices, beliefs, civil society, the clubs, associations, and competitive mechanisms. It's not a literal person. It's a people representing all of these things. And that's the material reality that must be understood within this field of unequal social relations. So some actors are going to have more power and exercise it more often than others. The next thing to consider then is the civic education gap, right? Because you might be thinking, well, I don't know anything about that whole last slide, constitutional as a system. And this is really the point of a class like this at an urban community college, is to ask, would you benefit from knowledge about this system? And some context just to consider is that there's a gap here between the writers of the Constitution, the lawyers that operate within it, corporate actors, people who run corporations. There's differences in the way people understand this system, and that benefits those people who understand it. And so if we just take some basic ideas here, most Americans have never read the United States Constitution. Most New Yorkers have never read the New York State Constitution. Most students I've worked with didn't know states have constitutions, right? That there's 51 constitutions in the United States. Constitutional law is mostly understood, used, and formed by lawyers. Elites, the wealthy, corporations, lawyers, judges, and more, they all benefit more because they understand this system, that they understand the processes, they understand private law, they understand the civil system, they understand all of these pieces and these written customs and all the things we discussed in the last slide. So I put this out there as a question. I think the answer is yes, right? Students would benefit from knowing more about this system, but you probably don't need to know more about the project. You need to probably know more about the system. But we have an additional problem. We've got this thing called fake news. So the traditional way of thinking about the Constitution or thinking about law in general is something called legal formalism, where we're going to try to say, well, the law is separate from social reality and it's an ideal, and we're going to see whether the ideal is holding up. Well, in that way of thinking, fake news shouldn't be a problem because there's laws that are supposed to prevent fake news, including fraud, libel, defamation, among others. But in reality, right, if we just look at social media, it's full of violations. There's fraud, libel, and defamation all over social media. And so obviously nothing's really doing anything to deter people from breaking these written customs and rules. And so we have to ask, well, why is this? Why is this happening? And so a socio-legal analysis would say, well, the middle class and the wealthy benefit from knowledge about fraud, libel, and defamation. If they're defamed on social media, they're going to go to court and they're going to sue you, right? Whereas if you're defamed on social media, you might not know what to do and might not know where to go. And so we're really just talking about a lack of people using their rights and using the court system to defend themselves on social media because they don't know how. So then we also want to think about this more complicated thing because, getting your feelings hurt is obviously bad and it can result in bullying and all sorts of other problems. But people would argue, well, it's not quite to the level of physical violence. And so we say, okay, so what about physical violence? Is there anything, about public statements and fake news and things that otherwise should be prosecuted as fraud, libel, or defamation that end up, turning to violence? Well, the best example in recent times is the January 6th insurrection. And we remember if we call it a January 6th insurrection or a criminal activity, that's the social control. We're saying here's the traditions of controlling this group of people by not allowing them to go and cause violence and property damage. On the other hand, you might say, well, don't they have a First Amendment right to assemble, to come together, and to protest? Is Trump responsible? Does he have a First Amendment right? Are the Oath Keepers another organization that comes together and promotes essentially fake news? Is Facebook itself, or Twitter, or any of these other corporations, are they responsible? Well, the constitutional law has a concept, a doctrine called fighting words, and those which by their very utterance inflict injury or tend to incite an immediate breach of the peace, those are considered to be fighting words. And so here's Trump's statement here, pieces of it anyways, and he's very clearly saying we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. He's blaming it on the election situation, this idea of draining the swamp, and he's saying that this is illegal. Again, fraud, libel, and defamation are supposed to prevent people from making statements like this that they can't prove, that they don't have any evidence of being true. And in this case, it might also be inciting an immediate breach of the peace. But that's, as a socio-legal scholar, I can say that. You sitting at home can look at this and say it, right? You can think about it, more and more and more. You can look into it more, research more. But at the end of the day, how should a judge interpret the statement above, right? Is this a crime? Is this a form that needs social control, or is it protected speech? There's no easy or clear answer. There's not a guidebook that a judge can look at and say, okay, yes, these words, exactly how they're written here, in the guidebook it says these qualify as fighting words, right? You're going to have to interpret this. What is the meaning of this? Does it make sense? Does it not make sense? And do you think it's going to incite an immediate breach of the peace? So clearly we have to get beyond legal formalism. Right? Legal formalism is this idea, again, that law is separate from social reality and simply a set of rules that basically anyone can apply uniformly, neutrally, and without bias, and that's usually legislatures and judges. But is this really a fact? I mean, no, of course not, right? It's a belief and an ideal. It's wouldn't it be nice if the world worked this way? And we know that because social scientists have proved this, right? So African Americans are more likely, even if they did nothing wrong, to be stopped for questioning and more likely to be arrested for suspicious behavior. This is evidence of implicit bias in the criminal justice system by race and ethnicity. We also see the same issues apply to Latinos. So prosecutors bring more serious charges against African American defendants than against white defendants. And so white defendants, even though they commit the same crime, are being punished less severely. More than 33% of prison inmates are African American, even though African Americans at the federal level, nationally, represent less than 13% of the population. So that's an enormous misrepresentation, or way more people than are represented, and obviously not consistent with who actually commits crimes. And black defendants convicted of murder or sexual assault are significantly more likely than their white counterparts to be later found innocent. So not only are we arresting and imprisoning African Americans, we're also finding out later that they were innocent, and so we call this wrongful conviction. But beyond race and ethnicity, there's also an issue of social class, right? Criminal courts are fundamentally courts against the poor. They don't get effective legal representation, and they're pressured into plea bargains. And so, again, this does go to their issue of what do they know about the legal system and process, but it also goes to the system, right? That the system is built against this group of people intentionally. We also have an issue when it comes to gender and sexuality. Women who are victims of sexual assault, domestic violence, and other crimes are taken less seriously, and they're often blamed for the violence that they suffered. There's also no federal law prohibiting employment or housing discrimination for LGBTQ individuals. So, in a nutshell, the rules are not uniformly applied by judges without regard to context. There's a large level of discrimination going on. People are treating differently, largely based on their access to the courts, their access to legal representation, their access to social power, and how they're treated greater or more largely in society in general. So if we want to look beyond the ideal, we have to look to social scientists who've proved more than enough cases of discrimination and bias that then push away this idea of legal formalism, that everything's automatic or neutral. But we want to still better understand, so what explains the gap? Well, go back to this idea that the Constitution as a system, literally, is the construction of federal and state government agencies and routines, whereas you and other people, everyday people, tend to focus on rights. So this is a huge gap between what the Constitution literally is, where it's just describing how to run a government, federal and state government agencies, and these routines, like when you're supposed to vote, those things, and what people are really thinking about it on the Constitution as a project, where they focus on their rights. But they don't understand how to enforce those rights. They don't understand the legal processes in which these rights actually exist. They probably don't know that there's this level of implicit bias and discrimination, that you might not even get access to the courts because of that. And then from the point of view of governments, rights only apply to human beings who deserve them, right? So this concept of good citizens, right? Do you know a senator? Do you know a lawyer? Do you have access to social power that allows you to get the benefit of these systems? And traditionally this has meant citizens who own property and lead communities. We think of this as territorial sovereignty. Are they acting like people with power in their neighborhood, in their community? And so again, you've got this bias towards the people who already have a great deal of social power. They're using the court system and the constitutional order to further benefit them. So you say, well, why does this happen? Well, this is the design of this particular Constitution. If you go back and read the Federalist Papers, and in particular James Madison and Alexander Hamilton, who are writing about, why this system is beneficial. Well, in their mind, the goal is to protect unequal abilities of getting and maintaining property. So wealth and influence is the goal of this particular system of government. And so if you don't have the traditions of getting wealth, handed down to you from generation to generation, then you're going to have to fight. You're going to have to engage in a form of political struggle in order to be recognized as a quote-unquote good citizen. And if you're not aware of this systemic bias, then you're really going to, have no clue, right? You're not going to be able to really make much use of this system as it is. Now, it's important, of course, to remember that just because that was the design of the system in 1770s doesn't mean that it has to be the design today. And in some ways, the 14th Amendment does undermine that idea. But again, a system, is handed down from generation to generation to generation, both as a set of beliefs and as a set of institutions, as a set of structures, as organizations that are operating a certain way. That's just the way we do things kind of idea. So this is, again, that tension of the old ideas versus the new ideas. So in reflection, the old ideas, or the belief that law is fair, neutral, automatic, and will protect your rights, we call that hegemony. It's working as a block that limits you from making social change in your everyday life. You're going to have to deconstruct those ideas and then move beyond them in order to make change to benefit you. And so that means that different people, based on race, ethnicity, social class, gender, and sexuality, are talking about quote-unquote law very differently. What we call this as social scientists is the polyvocality of legality. That's a mouthful, but poly, many, vocality, voices. So the many voices of what law is and what it means really just describes how you are conscious about it, what you're trying to do about it, how you're reacting to it, and then the schemes that you're putting together, these little strategies, the ways that you might make do, you just kind of go along with it, or the ways you fight back, or the ways that you try to organize with others. All of these things are given a big latitude in interpreting how things are going on in your life and how you're trying to make sense of them. And so this is going to inform how you make sense of concepts like fairness, justice, and sovereignty, things that are really important to the concept of constitutional law. So again, we want to think about this is, do working class students benefit from knowledge about constitutional law as a system and a project? And in what ways do you benefit? In what ways are you able to operate better in this system? Are you able to criticize the system better and recognize your own situation? That's what we're really going to be thinking about as we move forward.